Tom Kitty makes a strong point that income inequality is an issue that is of great urgency, because this issue really involves the greatest transfer of middle class wealth to the 1% that we've seen since the Depression.
Counsel, did you have anything further than what we have before us already today, or?
No, thank you very much.
Okay, terrific. And I didn't get your name, Counsel. Christopher King with Mortgage Movies.
You know my name, Kathy Salyer.
Oh, good to see you again.
I'm not going to speak on it.
Excuse me. We're here at KingCast, Mortgage Movies. Listen, people come to public courthouses to watch these events, and I broadcast these events because these are issues of extreme public importance, as Attorney Jones just noted. Now, honest judges and forthright litigants and their attorneys don't care, and they welcome my presence. Now, I'll broadcast the entire hearing later this week, but for now, you can see how Attorneys Salyer and Dubay hate my cameras, and that is because their guilty conscience has them all crossed up. At least her conduct was nowhere near as reprehensible as that of prior counsel Joe McIntosh, when on one occasion he and Luke Wozniak reneged on an agreement to allow video depositions and tried to threaten me with arrest. Okay, I told them in no uncertain circumstances to go to hell. Now, under these circumstances, I don't have to keep a civil tongue. I've had enough of these big bank lawyers threatening homeowners and me with no legal basis whatsoever, so I'm going to say it again, guys. To the extent that you believe you can disrespect me with no consequence, I'll let you know you better pump your brakes, because I'm going to tell it, and I'm going to tell all of it. Now, it is not my first time at this rodeo, you guys, and you just don't scare me with your bullshit.
I'm not here to fuck around this week. Now, you may be, but I'm not.
It's going back to Clem and Walker.
Please get out so we can proceed.
Counsel, don't talk. Watch your tone, okay? I'm packing up, all right? Watch your tone to me. Thank you.
Please get out.
Watch your tone.
Listen.
I am an invitee and I'm packing up.
You're not an invitee.
Oh, yes, I am.
No, you're not.
Oh, yes, I am. I'm at least a licensee.
This is not
I'm at least a
public
licensee. Yes, I'm at least a licensee. You want to get on that? Let's get on it. I'm packing
You
up.
to come swear you out here?
Do it, and I'll video that. You don't scare me, counsel. That, my friends, is the exasperated sigh of McCarthy Holthus Jr. Attorney Joseph McIntosh. Well, folks, we see how the defense counsel here acts sometimes. They didn't want to be seen on camera, but you guys want to be seen, I guess, right? Yeah.
Plaintiff's counsel.
Plaintiff's counsel, rather, yeah. So,
It's just like we win.
does anyone here have a comment you'd like to make? Ms. Pooley, do you have a comment?
I'm a little disappointed that the mini RICO did not survive, but
Sure.
I'm pretty darn happy that the fraudulent concealment did. So.
That's a major hurdle.
Yeah.
Yeah, and they don't like it. That's why they hid for my cameras.
Right.
Yeah, that's a total fact.
That's great.
Okay. Well, I think it was well argued by both sides, as I've come to expect in this case. And here's how I come out on the RCW 98-9A issue, which is also, I guess we're going to call that the criminal profiteering aspect of it. And there's a case actually, State versus Strong. It's a Court of Appeals case from 2012, 167 Wash Act 206. And that dealt with extortion and what extortion is meant to get to. And what this says is if a prospective plaintiff, let me give you a page number for this. This is at page 219. If a prospective plaintiff threatening litigation has or reasonably believes he or she has a claim of right, or threatens litigation with a nexus to a plausible claim of right, the threat falls outside the scope of the extortion statute. And Washington law does not require that the claim of right be proved. So what this, in my view, is getting to, and this is dealing with the exact statute that we've got at issue, but in a criminal sense, not in a civil sense, is what is the point of extortion? What are we really trying to get at? And for there to be an extortion. And extortion is where there's no plausible claim of right and the only leverage to force the payment of money resides in the threat, where actual disclosure would be counterproductive, and where compliance with the threatener's demands provides no assurance against additional demands based on renewed threats of disclosure. That's an inherently wrongful threat. And here what is missing is any allegation or ability to allege that the quality loan folks had no reasonable belief or claim of right in what they were doing. And whether or not they ended up being right about who the beneficiary was, whether or not they ended up being right about a lot of things, to me, doesn't mean, though, that they still did not have at least a reasonable belief in what they were doing. And that's what really the case law is getting at in terms of a threat and extortion, because honestly there actually are First Amendment issues there in terms of your freedom of speech and what you're doing, and that's what the Strong case dealt with. I also think that under the 9A, that clearly we don't meet the definition of unlawful debt under 9A 82010 subsection 21, and I don't think that this is also meeting the definition what was the other part of it? Of extortion as defined by 120 and 130, which then reference threat as defined by 9A 04110 subsection 28 A, B, and C, and allow a claim for extortion or for that criminal profiteering to survive in this case. So I'm going to grant the 12B6 as to that claim. I'm also going to grant the 12B6 as to the physical presence element of the CPA violation. It's clear to me that that they did, in fact, maintain a physical presence and have telephone service at the address as required by 6124.030 subsection 6. To the extent that there was any kind of conflict of interest there, or to the extent that there was any payments made by a third party or a different party, maybe even a co-defendant, there are no allegations that have been made or can be made, in my view, that that fact has caused any harm to Ms. Pooley as required under the CPA, and so I'm going to grant that motion as well. In terms of the fraudulent concealment, I agree with plaintiff on this one. I think the duty of good faith is what is going to save the day there in terms of the affirmative duty to disclose. So I'm going to deny the 12B6 as to fraudulent concealment, and I'm also denying it as to any other. I think the main one that I've covered in granting on the CPA is the one I just granted. To the extent there are other CPA violations that they seek to dismiss at this stage, I'm denying that. And also in terms of striking the allegations under CR 12F, the allegations that are really at issue, while arguably immaterial under that rule of 12F, honestly, I don't think there's a point to strike them. What a judge does down the road, because the judge is the only one that can take judicial notice anyhow, is really going to be up to that judge. And whether or not the parties are sad with this news, but today is my last day on this case. I'm transferring to Harborview, and so I won't be on this case anymore. I'm going to leave that for the judge that's next assigned to this case to decide what kind of judicial notice that judge wants to take. But I'm not going to strike those allegations from the complaint. So, can you guys work on an order that's consistent with my oral ruling?
Well, the court is leaving the bench, so.
Well, I'm not leaving the bench. I'm just leaving this bench, and moving my offices up the street to Harborview. So I will be around. You guys can certainly just email it to me. Preferably this afternoon would be ideal. It's pretty easy. You can even write it up if you want. Granting on the on the criminal profiteering, granting on the CPA as to the physical presence, in all other respects denied.
We'll get it done.
Okay.
Thank you, Your Honor.
Good luck to you, Harborview.
Thanks so much. Ms. Pooley, you take care.
We've had recent cases like Lyons. That gives us a lot to work with. But litigation is expensive, unpredictable. There's so many moving parts. But you know, we had a small win today, and you know, I take my hat off to these attorneys. Richard Jones, I'm very impressed, and we just keep plowing ahead. We're making progress.
Terrific. Thank you, Ms. Erickson. Do you have a comment today?
I feel very happy about this. It was like just said, it was one step back, but several steps forward, I feel.
I do too.
Right. This is quite a win. Fraud is a great win. So, and it was the judge said that it was well litigated by both sides, and that's what we need is pros and attorneys litigating every chance they can to fight this battle so that the people can win in the end.